All right, thanks everybody for coming. We'll start up, even though some people are coming in, because we have a lot to do for this evening. I really appreciate all of your coming here. It's kind of unnerving to give an event and not know whether anybody's going to show up except us. So thanks for showing up. First of all, just a couple of matters of business. The first is please turn off your cell phones if you have them on. Right, I always forget mine. Note that this forum is being taped by MCAT here and will be put into DVD format and also on YouTube, I believe, for distribution around the state. I suspect that from MCAT you will be able to buy DVDs later on of this presentation if you want to hear the whole thing over again. So maybe you won't need to record it on your own recording devices, which everybody except me has. I have the only dumb phone in the room, I'm sure. Okay, first of all, I want to thank two people who have just really put this event together. One of them I see right there, Sue Kirchmeier, would you come in? Let's give her a round of applause. Sue is the chairperson of Missoula Moves to Amend, and she has really, really worked to help this come off. And where's Nancy? Nancy Lightford from the League of Women Voters. Thank you very much, Nancy. And Nancy is a veteran at this, so she's really helped us figure out how we ought to deal with all of the people we thought were going to come. So, why are we here? Well, we live, there's what I used to think of as an old Chinese saying, but I found out from an old Chinese person that it's really not. But it was, may you live in interesting times. And we certainly do, I think, whether it's an old Chinese saying or not. We live in interesting times. And politically, these times are really incredibly important for those of us who live in Montana. We need to know what's going on around us, both in...
Push it further away, it's too loud.
Oh, sure. Yes. Okay, is that better? Yes. Okay, good. All right, I'll get this right eventually. We need to know what's going around us, both in the state and in the nation, and we think that we have two really interesting and important topics to discuss with you this evening. Lots and lots of views are available about these topics, that's for sure. We get a lot of information. It's hard to know what information is right and what isn't right. It's hard to know whose view is being expressed. And so it's really going to be interesting to us to have this evening together just for a nonpartisan information issues forum so that we can learn about these two important issues. I want to tell you who the players are now for this evening. First are our speakers. Two of them are here, and I'll introduce them in just a moment. And a third, the other two are roundabout, and I'll introduce them later. They're going to be the focus of our attention, I'm sure. But we have other players amongst whom you all in the audience are important to us. And at the end of the evening, throughout the evening, you'll be asking questions. And at the end of the evening, you'll have time to talk with your neighbors, with candidates, political candidates who are here, and with representatives of the media. So we hope that it'll be a very productive evening for all of us. Next, we may have representatives from the media here. Are there representatives from the media here? From any media body, aside from MCAT? Thanks for being here, Ron. Okay, well, let's just proceed then. So we are the players of the evening. The plan is that we will introduce our first topic, which is going to be what's left. Oh, one more candidate. Oh, excellent. Come on in. Wonderful entry, by the way.
Now that I have your attention, I'd like to introduce myself. I'm Andrea Olson, and I'm running for House District 100, where I've been a resident and a lifelong member of that community. So I encourage you all to vote for me.
Wonderful, Andrea. Thank you. Okay, so we will first discuss what's left of the Montana Corrupt Practices Act since the Supreme Court decisions of recent years. And then we'll have a brief break. And then we will begin our discussion of Legislative Referendum 126 with another couple of speakers. And after each set of speakers, we will have some discussion and some questions. I want to say that each one of you probably has, thank you. Each one of you probably has a little card. Have the cards been given out, Nancy? Okay, so people are going around to give you cards, and if you don't have a pencil or a pen, let them know. And this is the way we're going to be asking questions for this evening. Once you have a question that's written down, just hold up your hand and somebody will come and get your card. And then, partly because it's being taped by MCAT, we want to make certain that all of the questions are heard. So for the first section, Nancy Leifer will be reading all of the questions, and then I'll just be dealing with the responses. Okay? All right. So I think that's about it, and we can begin with our event. Again, do as you think of a question, write it down and hold up your hand. Somebody will come and take it away from you, and not your hand, your card, and then we can deal with it after the speakers. So first, probably neither of these speakers really needs introduction. On my left is Anthony Johnstone, who is an attorney, a professor of law at the University of Montana here, relatively newly arrived, I think. He also has served as the solicitor of the state of Montana, and he participated with Governor Bullock, then Attorney General Bullock, in defense of the Montana Corrupt Practices Act before the Supreme Court. We're very, very glad to have him here because he knows a lot about what's going on with this act, and he's going to talk to us a bit about what the condition of the act is now and fill us in on what's happening with that. So, Professor Johnstone.
Thank you, Linda. So I think most of you in the room probably know the big backstory of Citizens United and American Western Tradition and American Tradition Partnership, and the question of corporate campaign expenditures in Montana. I want to put that in context and kind of zoom out a little bit from Citizens United as it recedes in the past and try to offer a bigger picture that may in some ways challenge the conventional wisdom, even as it was understood at the time when, as an advocate, I was defending the law with now Governor Bullock. And so my presentation will kind of have three parts. First, what was the Corrupt Practices Act, understanding that, I think all of these have lessons for where we are today. What was the Corrupt Practices Act? What happened to the Corrupt Practices Act? And then what is left of the Corrupt Practices Act and kind of where we are now? And I might propose some unconventional lessons based on the history and law. So first, what was the Corrupt Practices Act of 1912? That's the one we're talking about. It was one, I should disclose, maybe it's a conflict of interest or an alignment of interest. It's one that my great-grandfather, who was a Republican newspaper editor in Fort Benton for the River Press, was a proponent of and editorialized on behalf of. And so it's one of those things where 100 years afterwards, I saw the act that he helped pass be struck down by the Supreme Court. So that's where I stand, at least family-wise, in relation to it. But contrary to the conventional wisdom, the Corrupt Practices Act, and part of this turns on some really good work by a colleague of ours in the history department, Jeff Wiltsey, who wrote an article about this. It was not as simple as simply being targeted at the Copper Kings. Those of you who can reach back and remember your Montana history, most of the Copper Kings hijinks were at the end of the 19th century, and of course the Corrupt Practices Act that we're talking about was passed in 1912. William Clark, what made him infamous was a bribery scandal. He bribed his way into the Senate. He bribed his way into the Senate at the end of the 19th century, a dozen years before the Corrupt Practices Act, and that was already illegal to bribe your way into the Senate. We did not need there was an earlier bribery statute and corrupt practices statute that covered that. In fact, there was the way that early campaign finance regulation worked was it limited how much money anyone could spend on a campaign. And in 1895, Montana's first Corrupt Practices Act was interestingly targeted at Senate candidates, U.S. Senate candidates, limited campaign spending by U.S. Senate candidates and on behalf of U.S. Senate candidates to $1,000. That's $23,000 in today's money. And it also required, all the way back then, the kind of centerpiece of the laws Commissioner Modal now enforces, is it required that this spending be conducted by political committees. And those political committees had to file disclosure returns that reported their expenses. And in fact, if you look all the way back at the records of when the Senate kicked Senator Clark out, refused to seat him, there was already thorough information, right? For example, they'd gone back, they were able to look at Daley's books, for example, and see that Daley had given $1,000 here, $5,000 to the Butte party, and he'd reported all of his campaign contributions, and that was well before the Corrupt Practices Act. So Clark didn't. He destroyed all of his records. It was dark money before the term existed, and while and in terms of being limited to $1,000, he spent more than $100,000 in the campaign. He and his associates. So he blew out these campaign limits, and it was that, in addition to the bribery, breaking the contribution limits, breaking the spending limits, and not disclosing, that got him in trouble with the Senate. And it was the Senate that refused to unseat him. The Corrupt Practices Act that we think of that focuses on, as one of its measures on corporations, is the Corrupt Practices Act of 1912. That is in response, and I think it's worth considering, not to this kind of obscene, throwing $1,000 bills over the transom to bribe legislators activity. It's in response to much subtler phenomena, although still not very subtle. In 1909, first of all, in 1906, Montanans added a provision for the initiative in our Constitution to create a path to do an end run around the legislature if the legislature were captured by the company, as it turned out to be. In 1909, the then amalgamated company, its lobbyists had basically forced through a bill that they wrote that legalized monopolies in Montana. And in terms of forcing through, what they did is they wrote the bill, and this state legislator from the Flathead, who stood and gave a speech in support of it on the floor, started explaining why it was so important to pass this bill. And the reason it was so important to pass this bill is because the company was behind it, the company wrote it, the company had given a bunch of money to him and his buddies in the party, and so it's really important. And he goes on, and this guy stands up on the floor and says, that's enough. That's enough from you. The person who did this was not a legislator. It was the company's lobbyist was actually on the floor and would speak during the sessions and silence people who didn't toe the party line. And then in 1911, they'd worked to block the appointment of reform-minded candidate Thomas Walsh to the U.S. Senate, and scuttled some other popular reforms, the beginning of looking at mining taxes and things like that. So that was, it wasn't just the Copper Kings, it was the company, really, and its much more sophisticated network that prompted the 1912 Act, which then passed overwhelmingly, 76%. one of the things that it in some ways, and this is something that again is not well understood, unfortunately we Montanans, or not even my great-great-grandfather, can take credit for it. It was basically just imported wholesale from Oregon. It was a Corrupt Practices Act like many of the Corrupt Practices Acts that were being passed all around the country, and it was just taken almost verbatim as an initiative. It was a very long and complex initiative, actually. It dealt with some things that the Montana law already dealt with and added some new features. And importantly, it was twinned with the direct election of senators. That was a very important piece of the reform. First of all, it limited all candidates' election expenses, not just for Senate, and it limited them based on their salary. What were the limits there? Well, it was 15% of the office's salary for the nomination, and then 10% of the salary for the general election was how much they could spend, at least $100. The governor's salary at the time was $7,500, so that worked out to be about a $1,000 limit for the governor's race too. Kind of, not much of a change. Again, about $23,000 of spending limits in today's money. The other thing it did is it required disclosure. It required committees to account, again, in all races. And its threshold for disclosure, and I'll return to this, these thresholds I think are important in terms of seeing the big picture here. The thresholds were, if you spent more than $50, you had to file, I think with the Secretary of State, or the county clerks. $50 at the time was the trigger. That's about $1,160 in today's money, so well over $1,000 in order to disclose. And you'd have to disclose all the receipts and contributors, your contributors over $5, about $116 in today's money. So back then, the threshold for reporting was about $1,000, and donors would have to be disclosed at around $100. That was one piece of it. The other piece, the centerpiece that became the focus of the Western Tradition case, are defining and punishing corrupt practices. And corrupt practices included expenditures and contributions in campaigns by certain corporations, not all corporations, certain corporations that had a particularly tight relationship with government. So the financial industry, banking, right, where you'd worry about them being too cozy with the government. Utilities and common carriers, railroads, people who are regulated, right, the kind of people who are today regulated by the Public Service Commission, and anyone who could exercise eminent domain, interestingly, right? Again, the concern, it was a very specific concern, that the corruption that they were worried about. They didn't want people buying their way into government abuse of power in terms of eminent domain, rate regulation of regulated utilities, or these financial companies. Those were the companies, the corporations that were focused. Then interestingly, it also prohibited it from nonprofits. So the 501c4s of the day, before there was a 501c4, were also prohibited from spending in these. There were other corrupt practices, betting on elections, interestingly, bribing, electioneering at polls, undue influence of voters, and undue influence of media. So no payola with ads or editorials. Everything had to be clearly disclosed. And then there were several other provisions. The first kind of election contest provisions, several things to protect the purity of the ballot. So it was a comprehensive reform. It was not just about corporations. It was a quite comprehensive reform, the Corrupt Practices Act of 1912. And this is one lesson to take away from it, is that, as we know, the Amalgamated and soon Anaconda Company easily evaded all of these things. I think we need to be honest in terms of the story of the Copper Kings and the company and the effectiveness of the Corrupt Practices Act. It of course wasn't, right? The copper collar persisted for decades after that, notwithstanding the Corrupt Practices Act. And this is something to learn in campaign finance reform. There's no magic bullet. The company, particularly through developing an information bureau at the legislature, before the legislature had professionalized staff, before the reforms of the 1960s and 1970s that gave the legislature professional staff, it was the company that provided the staff and educated and brought up people from both parties. And then, of course, the watering holes that Bob Brown at a recent conference in Helena told this amazing story from a former company lobbyist about how the legislators at the time in the 60s and even into the 70s would simply call that school. They'd go up, get their whiskey and steaks, and of course the whole point was to be educated on the issues by the company. And so that influence persisted, notwithstanding the Corrupt Practices Act. And of course they bought up a lot of the big newspapers. And so the Corrupt Practices Act was notwithstanding the act, one company lobbyist, and this is from Mike Malone's history on Butte, said, "Give me a case of scotch, a case of gin, one blonde and one brunette, and I can take any liberal." So that's what the Corrupt Practices Act is. It's a little bit more and a little bit less than what we think of it. What happened to it? Well, those expenditure limits were declared unconstitutional in Buckley versus Vallejo. Generally, you couldn't limit how much you spent on campaigns, and the court's rationale was a restriction on the amount of money, and this was a decision joined by the great liberals of the court as well as the conservatives. A restriction on the amount of money a person or group can spend on political communication necessarily reduces the quantity of speech and the size of the audience reached. So no expenditure limits. And so that centerpiece of traditional campaign finance reform was off the table now. Well, the disclosure piece of the Corrupt Practices Act, well, the court has generally upheld that. And so in Buckley, it talked about how important it is for voters to know where the money comes from. The sources of a candidate's financial support alerts the voter to the interests to whom the candidate will be most responsive. So no expenditure limits. Those were gone from the Corrupt Practices Act. Disclosure would be okay. And a new innovation in response to losing the expenditure limits are contribution limits, just contribution limits. Right? So you can limit how much money you can give to a candidate. You cannot limit how much money that candidate can spend or how much money anyone else can spend. Those are the basic rules. And so you can limit contributions, you can't limit expenditures. Citizens United is really simply a corollary of this, that you can't limit expenditures. Citizens United, the court recited this 1976 Buckley and explained that speech is an essential mechanism of democracy. You cannot, the purpose and effect of a corporate campaign expenditure ban is to silence entities whose voices the government deems to be suspect. And that is, under classical First Amendment doctrine, a problem. And so the court struck it down in Citizens United, but in some ways this was consistent with Buckley versus Vallejo. So that's the current, that's kind of what happened. You can have disclosure, you can have reasonable contribution limits, you can't have expenditure limits. The other piece of what happened in the wake of Buckley versus Vallejo to what was left of the Corrupt Practices Act are a couple rounds of reforms. And this gets us to from then to now in terms of the laws Commissioner Modell is charged with enforcing. In 1975, post-Watergate, the legislature adopted contribution limits. Right? It couldn't have expenditure limits. You couldn't control how much was spent, but you could limit how much they could take in from any one donor. Those contribution limits were $1,500 per governor in 1975 dollars. That's $6,400 today, and about $250 per legislative race, or about over $1,000 today. And it also required disclosure of $25 contributions or up. And so donors, right, if you gave to a candidate more than $25, you'd have to disclose. That was about $100 in today's money. The last piece of it was I-118, which came 20 years after this in the early 90s, 1994. And what that did, and that kind of sets up where we are today, is it ratcheted down the contribution limits and ratcheted down the disclosure thresholds. They're indexed for inflation, but right now the contribution limits are about $650 per election for governor, $170 per legislator, and disclosure of all contributions over $35, and that's not indexed, that's fixed. And this is one of the takeaways. Our thresholds now for contributions, what our predecessors deemed corrupt practices, and at $1,000 back in 1912. We have tightened that down considerably so that our current thresholds for contributions are about 1/10 of what they were in our post-Watergate reforms, in Montana's post-Watergate reforms, and 1/35 as much as the original Corrupt Practices Act. Our limits are much, much tighter than they were before. Disclosure is 1/3 as high as it was before. Well, why is that important in a world that we have both Citizens United and the court saying you can't ban expenditures, you can't even limit them, and the legislature is saying we're going to have very tight limits for contributions and very low disclosure thresholds? Well, it creates, I guess, what I'd call a zombie campaign finance system, where when you don't have expenditure limits, candidates can spend as much as they want. They have to, as a result, fear the dark money, the big money, and they have to embrace the biggest donors they can find and spend a lot of their time raising money rather than doing their job. It's this arms race of unilateral disarmament. In addition to that, to the extent you want them to rely on small donors, only donors who are willing to have their names put up on the internet are going to give over $35. So generally more partisan donors, there's some evidence of this, generally the most partisan people are going to be the ones who are going to donate to candidates. And where is the ordinary citizen in all of this? Well, in Montana, which actually does quite well compared to other states, only about 5% of Montanans are involved in campaign finance. Only about 5% of Montanans have a seat at the table in terms of that. For all sorts of reasons, but you can see that when candidates have to fear dark money, big money, embrace the big donors, we have a system that makes it very hard. It manages to catch all the small fry, but leaves many of the big fish out there. And that is not anyone's idea of a rational campaign finance system. I'll just leave by posing that. Again, it's an unconventional account, but it's worth noting what the Corrupt Practices Act was about. It understood how the whole system worked. Thanks to the Supreme Court, we may or may not agree with them, and at least until we have a constitutional amendment, which I think is pretty unlikely, we have this zombie system, which is really the worst of both worlds. And one suggestion I'll have kind of just as a takeaway in conclusion is there's always going to be money in politics. There always has been, there always will be. Money is like water. You can push it away out of one system, but it's going to go someplace else. We might, given dark money and given how much big dark money there is out there, and how many citizens are at the margins of this, we might consider deregulating around the small fry and focusing most of our attention on the big fish. Because I think the question is not how much money is in politics, but whose. And the answer, I think, ought to be ours and not theirs. And something would need to change to make that the case today, because right now it is theirs, and we are standing on the sidelines.
Thank you very much. Thanks very much, Professor Johnstone. I next have the honor to introduce Commissioner Jonathan Mogul. He's also an attorney, and just back in June of 2013 was confirmed as the, I believe, 11th Commissioner of Political Practices here in the state of Montana. So, as Professor Johnstone has indicated a couple of times, we rely on him in his office to make certain that all kinds of political laws are enforced, are followed in our state. So Commissioner Mogul is going to talk to us a little bit about what's left, where our protections are coming from now that we've had some limitation of the Corrupt Practices Act, and how we can be sure that our rights as electors are being protected in the process. So, Commissioner Mogul.
Thank you.
Oh, move the tulips. I love the tulips, but I don't.
And I just, is that all right? Can you hear me? No. Closer? Now can you hear me? It must be off.
Oh, huh. Here we go.
There. Okay. I just have to correct one thing. I am not confirmed yet. I'm appointed. The confirmation's by the Senate, so
Right.
that process has yet to occur. I'm very pleased to be here. I'm very pleased to follow Anthony. The office that I hold is the Commissioner of Political Practices, and political practices, at least in Montana, includes lobbying, enforcement of ethics law, and enforcement of campaign practices. And it is, of course, the campaign practices that Anthony was talking about, and it is the campaign practices that everybody seems to be interested in today. But before I begin, I just would like to ask a favor. Would you folks, just in this part right here, would you please change places with somebody else so long as you're not sitting next to the person you're sitting next to now? The rest of you can just watch that.
This must be an object lesson.
It is an object. And Mr. Bollinger, as usual, strikes off into the wilderness. Okay, so what exactly then is campaign practices? And campaign practices, at least as interpreted now, means that it is an activity involved in a campaign that, as far as my office is concerned, involves money. It is an expenditure of something of value on behalf of or against a candidate for office. Now, that value comes into the political process in a couple of ways. In the course of running for office, in that moment, a candidate, and those candidates here, they are one of us. They're moving into a public office where they will be imbued with public trust once they're there. But in that brief period of time when they're running for office, it's not the same as when they are in office. When they are in office, then people lobby them, and the lobbying regulations apply. They're imbued with public trust, the ethics law applies. But in that moment when they're running, society places a lens on them, and they're simultaneously, humbly, hopefully, seeking power. But in that moment, everybody can evaluate them. Now just think about what happened when people change places over here. That's the simplest form of change that there can be. It's just physically changing place, one person to another place. But even then, if somebody came in sitting next to the person that they love or wanting to sit next to them, they might not have liked that change. Well, that's what candidacy is like. When people are running, in that particular moment, we put a lens on them. And even though you may know somebody well, now you're judging them as to their ability to represent us in a particular type of way that we all try to work together. That lens tells you whether that person is going to be able to properly participate in governance. So how do we do that lens? And in the end, if you listen to what Anthony says, that is what the campaign practice laws should accomplish. So how do they accomplish that? How do they tell you something about that candidate running for office? Well, they tell you in this way. As the money comes in, that money should say something about what the candidate does and what the people that are spending the money believe the candidate is doing. Now, we have two forms of money coming in that there is no accountability for, there is no disclosure on, there's no reporting on. If money is used to influence a campaign, but it is designed and used mainly around an issue, And you're probably all familiar with this word. It's called issue advocacy, and that, of course, is the famous swift boating exercise that we saw with the presidential candidate. If the money is used on issue advocacy, focused more on an issue than it is on the candidate, that money is not reported or disclosed. There is no information you're going to see on an issue advocacy expense on a candidate for office in the state of Montana that is going to be reported or disclosed through the Commissioner of Political Practices. The second item of use of money that you won't see is if the person spending the money is claiming anonymity. Now that's a pretty isolated use, but again, there's all sorts of constitutional law in it, and if Anthony had time, he would have talked about that. He would have talked about the constitutional law related to issue advocacy. But if somebody produces an anonymous flyer and they're standing on the corner in Missoula and they're saying Sue Mellick is the greatest candidate that ever lived, no name, no disclosure, but obviously they spent some money on that flyer, that's going to be legal. If it's an individual doing their own advocacy and not wanting to put their name on it, it's an entirely different matter if it's a mass mailing of something anonymous, as is occurring in Lou Jones' legislative race up on the Highland right now. If it's a mass mailing, anonymous, stamped with no name on it, that's not right. If that person is discovered, that will be a campaign practice violation. So let's talk then about what's left of the Campaign Practice Act and what the commissioner can do. Expenditures or contributions that don't fall in those categories are subject to basic reporting and disclosure. What the commissioner's office does is, with a very small staff, it's actually 3 people, they take in every campaign finance report in the state of Montana, whether it's by a political committee, whether it's by a candidate. They take those in, and we're just getting into the real time right now, so we're actually starting to get them electronically. But up to this campaign cycle, they were taken in, scanned, and a scan of it was placed on the website, and those are available off the commissioner's website for review by anybody in the state of Montana, 24 hours a day, 7 days a week. They make that information available. It gives you the information, just like you saw these people move. It tells you something about who's supporting and who's opposing a candidate. And who has to report? Well, reporting and disclosure is required of the candidate. It's required of anybody contributing to the candidate if you're a political committee, if there's 2 or more people, and it's required for express advocacy. Express advocacy means that somebody independent of the candidate is making an expenditure on their behalf, and that information has to be reported and disclosed to the commissioner's office, and there is an exception to that, and I know I'm being too technical here, but if it's a company that in the ordinary course of business gets its money in, and it is using that money since Citizens United, they are now allowed, even if they're a corporation, to spend that money. It used to be that corporations could only spend money on initiatives, but now they can spend money on candidate races as well as a result of Citizens United. So, for example, right now, the Montana Family Foundation, which is a 501c4 corporation, is sending out a large number of brochures in a considerable number of legislative races all over the state of Montana. And those brochures are attacking one candidate. They're not saying anything about the other, they're just attacking one, and they say, well, no, that is express advocacy. That has to be reported and disclosed if you are a political committee. If you are, as Montana, as that particular organization is a 501c4 claiming to use its corporate treasury, you do not need to report the source of the money. You just have to report the expenditure, if that makes sense. I don't know if it, I realize it doesn't make sense, but that is what the requirement is. So what does the Commissioner's Office do? Its basic function is to provide information on the money coming in and being spent on campaigns, and to make that available to the public as quickly as we can and as thoroughly as we can. Along with that, then, there are still prohibitions and one ban left in the law. We still ban direct corporate contributions to candidates. So a corporation cannot directly contribute to a candidate campaign in the state of Montana. And there are contribution limits for political committees, for individuals, and for anybody else involved in a campaign, even political parties. So those contribution limits are also enforced by the Commissioner's office. And then here is the kind of hidden function of the Commissioner's office that, as Anthony has said, you can have good laws, but unless you use them and enforce them fairly and evenly, really the law can be ignored. The campaign practice law in the state of Montana, passed in '75, amended a few times, is incredibly elegant. And I think John was involved in the writing and passage of that. Were you, John?
Which one was that?
The 75?
No, that was before my time.
Okay, that was before your time. But it has within it 3 levels of involvement in the commissioner in those reports and disclosure that come into our office. They are inspected within 20 days. Every campaign finance report is reviewed by a member of the staff, and in true Montana style, that is a safety area where, let's say, some candidate inadvertently took a check from a family farm corporation, not realizing that they can't take corporate money. In that 20 days, our staff will spot it, will contact the candidate, will tell them they inadvertently took an illegal corporate check. They will go back to the individual who issued the corporate check. They'll get that check from a personal account. It's corrected. There's no error, and I think that's true Montana style, where we focus on major issues and not on minor issues like that. Also, within that 20 days, if a major area of problem is detected, the commissioner has authority to go past inspection and actually go in and do a mini audit of whatever entity you spot that is involved in incursions into candidacy campaigns that are not proper. And if that power had been exercised in 8, 10, and 12 in regard to Western Tradition Partnership, we wouldn't be into the area of solution, which is the third area I'm going to move into, which is the filing of complaints. So we have inspection powers. Following inspections, we also have audit powers. At the end of every campaign cycle, the final report filed by a candidate or political committee can be audited by the commissioner. That has never been done either. But it's possible that we can go in and audit political committees' candidate campaigns where we believe that reporting and disclosure or some form of adherence to the contribution or the ban limit has not been properly followed. That hasn't been done either. The third area that we get into is the filing of complaints, which is the traditional area that campaign finance law is enforced in Montana. Complaints are filed with the Commissioner of Political Practices Office. The commissioner has authority then to investigate those complaints. The commissioner, upon investigation, issues a decision that's available on the website. The decision decides whether or not sufficient facts are found to demonstrate a violation of the Campaign Practices Act. What facts are sufficient to demonstrate a violation? The facts that have been found in regard to 8, 10, and 12 campaigns focus mainly on the involvement of a particular corporation, Western Tradition Partnership, with its affiliate, now American Tradition Partnership, who had a number of affiliated corporations and groups with it, who worked in coordination with the candidate, and they did it in a pretty elegant way, sophisticated way. The corporation would work with the candidate to produce 8 candidate letters, generally between May and June of the primary. They were all Republican primaries. At the same time, they would work with a number of outside entities to produce glossy, oversized postcards attacking the Republican primary candidate they did not support. And then there would be surveys issued by a number of other groups who would then write a letter further attacking the candidate they did not support. All of those coming sometime between May, the first week in May, and the end of the June vote. Those decisions have found sufficient facts to show a campaign practice violation in the form of coordination. Coordination simply means that the entity making the expenditure is working so closely with the candidate that the candidate knows of the expenditure, and the expenditure is no longer an independent expenditure, a contribution to the candidate's campaign. That contribution is banned if it's a corporate expenditure, and it's limited to the contribution amount if it's not. That's the essence of those decisions that the office has released in the last 11 months, catching 9 candidates for public office, and hopefully, and I believe successfully, educating the 2014 candidates so that they are avoiding contact with these corporate entities. Why is it bad for our political process? For the very reason Anthony said. The governance depends on the trust of the public in the people who are governing. In the end, the success of our society depends upon the acceptance of the integrity of the people we elect to be public officials. That lens of the election gives you an insight into the character and the nature of that person, and the ability to balance the humbleness of representing people with the power you get as their representative. Those are two almost competing things, and I think an office holder has to be conscious constantly that those two things are there. That's what we need in governance. All of us have passions. All of us believe things passionately that we would do if we were dictators, but that may not be what you do when you govern. When you govern, you have those two things that you're balancing, and that's what the campaigns should show if they're done right. So I think we do need to tinker with how we do these campaigns, but more than anything else, we need to increase the debate on campaigns. We need to increase the understanding of how we deal with elections. We need to make electoral discussions as prominent as football discussions. And when we do that, we will improve, I think, governance, and we will improve the way that, that government functions. That is what I see the Commissioner of Political Practice's primary function being. It's to increase that discussion. It's to try to hold that dual function. The office respects every single candidate running for office. That is, there's 1,000 people, approximately, in the 2014 election cycle, who stepped forward from all of us Montanans and are running for one office or another all over the state of Montana. And we all owe them a debt of gratitude for that. And so the office respects that position. But at the same time, on behalf of the public, we have to speak for the public about that lens of what happens during that campaign practice period in regard to disclosure and reporting of the involvement of people in the campaign. I think it's a fair system, and I'm surprised by the elegance and the strength of the office that's left, even though some of the prohibitions may have been stricken. There still is quite a bit of ability there for the office to speak on behalf of Montanans and hopefully improve the way the electoral process, that lens when you look at a candidate, works. So, thank you.
Nancy, do you have some questions? Has anyone turned in questions? Put up your hand if you have questions, and somebody will come and get them from you.
I have a question for either one of you, probably for Professor Johnstone. And excuse me if I stumbled just a tad bit, but I think I have it here. Should the court have distinguished Buckley from Citizens United, given the fact that Buckley was dealing with a corporation that was media-oriented and had to have the freedom of speech or the First Amendment rights? Not all corporations deal with the media and speech to exist. In Citizens United, it was showing a film on Hillary, but not media.
That's a great question. The court, if it wanted to, could have reached a much narrower ruling on the campaign advertising at issue in Citizens United. It was a very odd kind of campaign advertising. I'm not sure that it's fair to call it that. It was an on-demand 90-minute movie about Hillary Clinton. Not the sort of thing that you get in your mailbox the week of the primary election. So the court could easily have dodged it. I think its concern, and this is a concern that you often see, particularly in the First Amendment, where it's about the last thing you want is for the government to censor groups based on the content, is it wanted to draw a bright line, and it's debatable or not, but it becomes pretty hard to draw these lines. So no corporations, well, I suspect the League of Women Voters would be a corporation. Montana moves to amend. It's a corporation. Okay, well, so no, only for-profit corporations. Well, then you have the media to address. Should the government decide who's the media or not? Although the First Amendment discusses freedom of the press, that was likely meant to refer to a technology in terms of the printed word, or today a blog, as opposed to an institution. So the court, again, there are lots of places where you could have decided it without drawing these bright lines, but the court drew a bright line because of these concerns that if it didn't say that everyone can spend in elections, it was leaving the government the possibility that it could say, no, you can't. And the government had a tough time coming up with answers to the questions about, could you ban books? Book publishers or corporations, could you ban a book? And those sorts of slippery slope arguments convinced the court to draw, whether it's wise or not, it is a bright line to say that corporations, unions, everyone can spend.
These are two questions, I'll put them together. What would it take to change the Constitution to fix the Act, and are there any legal problems with Montana writing its own disclosure laws?
So a constitutional amendment requires, Article 5 of the Constitution requires 2/3 of Congress, good luck with that, or conventions called by 2/3 of the states, 34 states. And then any amendment would have to be ratified by 3/4 of the states. The reason why constitutional amendments only come during real sea changes and only come when they are deeply bipartisan, like the Corrupt Practices Act of 1912 was, is because if you do the math, one house in 13 states can block a constitutional amendment. You need something like, so just 10% of the population in the red states could block a constitutional amendment. 13% of the population in blue states could block a constitutional amendment. So you need not unanimity, but 90% consensus on an issue. It has to be bipartisan. And so when you see amendments such as expanding the franchise, they come at moments in history, for example, giving the vote to 18-year-olds, a big cause of Senator Mansfield. It's because there's just this 90% consensus. There's not 90% consensus around this. At most, when Montana lost its Corrupt Practices Act, only, depending on how you count, 26 or 24 states even had them. So there's not consensus at all on this issue. In terms of disclosure, I think that even under the laws that are written now, Commissioner Modell has a great deal of authority, and it's all constitutional, to go after, I think, even 501c4s. I think the court so far has been pretty liberal in allowing states to require strong disclosure. And I think our current laws allow it.
You want to speak to that, Commissioner?
Well, I think there is authority. The exercise of authority, when it hasn't been exercised in the past, sometimes creates a few ripples, though. So one has to be careful how you do it. So we have nine judicial actions filed against candidates from the 2010 campaign right now, including 3 sitting legislators. The last time that was done was in 1940 with the sheriff out of Cascade County, who was, before the time of the commissioner's office, it was done by a county attorney under the old Corrupt Practices Act. The sheriff was actually removed from office after election, and the transgression that the sheriff engaged in was providing beer and sewing kits to voters. The transgressions that I think are the most serious in this cycle are the very ones that caused the Corrupt Practices Act in itself. That is that the three sitting legislators, even though they're under a statutory requirement to keep their campaign records for up to 4 years, or the term of office, whichever is longer, didn't produce their records to the commissioner. Absolutely refused to do it. That is the public trust issue that maybe they'll produce it to the court. They're in court now. But that, to me, is the most fundamental obligation you have, is to demonstrate that kind of willingness to accept that humility that is part of the acceptance of public power at the same time.
Thank you. Do you have another question, Nancy?
Yes. Regarding disclosure by 501c4 corporations, do IRS laws or regulations prohibit disclosure of donors to the corporation, or merely do they just not require disclosure?
And Anthony may want to add to this, but if you're a 501c4 organization engaged in express advocacy and you register as a political committee, you have to disclose your donors and your expenditure. It's only if you claim to be that your activity is incidental to the corporate purpose. And before this last round, all of the incidental examples were in the ballot initiative arena, where corporations were involved, but Orvis Company set the standard in Montana. They engaged in activity on behalf of I-122, the Clean Water Initiative, and a corporate secretary produced a letter which was mailed to corporate customers on behalf of the initiative. And the commissioner office, that would be Commissioner Harkenbright, found that the failure to include the cost of the letter was a breach of the Campaign Practices Act. But the important thing on that is the money to pay for the letter didn't come from a donor. It came from Orvis's regular income from selling fishing products. So that is what an incidental committee is. The activity of that 501c4 is incidental to its normal corporate purpose, and it's its normal corporate funds that are being used, not money specifically donated to the corporation. Now, is that the case for some of the C4s that are claiming that today? Maybe. And that is where the audit functions come in.
This is, 501c4s are one of my pet peeves. Montana law has since 1895 say that a political committee subject to disclosure is 2 or more persons who contribute or spend money to influence the outcome of an election. It has nothing to do with 501c4s. It is a total red herring. Give me 2 people who are spending or contributing money to influence an election, and at least on the face of it, they trigger the disclosure laws. Now, this is where part of the trick comes in, but when a corporation does it, it's not a problem that Orvis doesn't disclose its donors or its customers or its shareholders are, right? You know who Orvis is. But most of the 501c3s or C4s that are abusing this, it's just a simple question. If you actually can look at, they have to file tax returns. You can look at the tax returns. That's one good reason that they're 501c4s. They at least have to disclose that. And you simply ask, what are you in the business of? And most of these dark money groups, and I think Western tradition is likely one of them, you would see that all of their money, almost all of their money, is coming through donations and are reported. They don't have to tell the IRS who their donors are, but it's coming in through donations. And most of their money is going out for campaign expenses. If that's the case, there's just not a question under the law. They have to report their donors, no matter what the IRS says. The IRS is not I think we're learning this, it should not be, and is not in the business of state campaign finance disclosure. If you're 2 or more people and you're in the business of influencing campaigns, if that's what you're spending most of your money on, your donors should be an open book. But I think it's that simple, and the 501c4 has been kind of a smokescreen in some of these things.
Is the McCutcheon ruling going to increase or decrease the transparency of who are the donors? The McCutcheon decision.
I would have to say that just echoing what Anthony just said, it's the diligence, the political will, and the ability of the state to enforce the laws it does have. McCutcheon aside, no matter what laws you've got, if you can't enforce them, they're not going to mean much. So McCutcheon did nothing, as far as I can tell. Maybe you think differently, Anthony, but it didn't say any. It didn't lay any further restrictions, limits, prohibitions, or barriers to reporting and disclosure. The barriers that are there. The Commission on Political Practices is a 6-person office. Never had an attorney till I was appointed commissioner, and I'm an attorney. And then at the same time, in August of 2013, the legislature funded another attorney, so we actually have 2 attorneys in the office right now. But that's the first attorneys the office has had. In order to enforce, to look at a C4 and say, yes, now mind you, Western Tradition Partnership was a C4. Its affiliated entities that it created to carry out its brochures, and they changed each of the election cycles, were also C4s. They were formed in Colorado. And then it had a for-profit print shop, also formed out of Colorado, Direct Mail. So it had a for-profit corporation, 2 primary not-for-profit corporations. They didn't report at all. Their position was that anything they did was express advocacy. So we never got even to the type of reporting where a C4 is claiming to be an incidental committee and only reporting expenses, not reporting contributions. We weren't even at that level. And so you first have to enforce the reporting and disclosure, and then we can see if the entity is properly reporting and disclosing. But it's an unending battle. I mean, you have to keep at it.
Here's an argument as to why McCutcheon should increase disclosure, and it's an argument that the court made in its majority opinion. It's an argument that I think is compatible with the broader points that I've been making. Generally, people with up to, say, $3.2 million would be, if you maxed out to every possible congressional party and candidate committee under the federal system, I think you could give something like $3.2 million. It's a lot of money. It's 1/10 of 1% of the total amount spent last cycle on these things. And so it probably is, if you're worried about corruption, well, you're one of 1,000 people and you might get some face time for that. Probably not much more, and we need to be realistic about it. But why would it increase disclosure? People who are throwing around $3.2 million, the reason they have $3.2 million is because they're not experts in campaigning. They would much rather give it to contributors, just like many of us would, right? Rather than maybe writing a letter to the editor is a great trick, but rather than taking out an ad in the Missoulian or buying a billboard, wouldn't you rather just give the money to the candidate you support to get their message out? Everyone thinks that way, including people who have $3.2 million. Sheldon Adelson would love to give $3.2 million to everyone. And if that's the case, that's disclosed. that money is disclosed. And so McCutcheon may well lead to, it will lead to more influence of the people who have $3.2 million to spread around, but they will be disclosed. It will not be dark money. And that's one argument that McCutcheon could increase. And deregulation in general, in terms of raising contribution limits, could increase disclosure.
We have 4 questions here, so let's try to answer these last 4 and do it shortly as opposed to lengthily. Do you think the court decision in stripping Rick Hill from using the last $500,000 donation at the end of the governor's race was correct?
Yes, can I elaborate? So that's a great example of just how important it is that we have a sophisticated commissioner. That money has been traced through two different national PACs that have to the extent the sleuthing is done, it is traced to a mailbox 2 blocks down, a building there. If there were a window there, I could point to the building where the money came from. That's all we know about it. This is why we need investigative journalists and commissioners with big staffs who aren't playing whack-a-mole with Western Tradition Partnership too, and can really look into those things. But that's the bottom line. That money came from a place, and we still don't know where it came from.
What's happened to the referendum sponsored by several GOP state legislators who may have been defeated by illegal actions by outside groups?
That would be the dark money. Do you know? I know Anthony. If you you oh, okay. And so the 7th Circuit today struck down Wisconsin's pretty stunningly blunt decision, struck down Wisconsin's attempt to limit express or to have reporting and disclosure of express advocacy when they said it was too detailed, basically. That initiative is out for signature, but if I were them, I'd look pretty carefully at what that 7th Circuit said about express advocacy before it goes further. But it's out for signature gathering right now. If it gets enough signatures, it'll be on the ballot. It is stunning that we're in an era, and I know some of you don't agree with this, but we're in an area where less is more. Where if you regulate a heavily regulated political committee, if you require, for example, as Wisconsin did, a $100 registration fee to register as a political committee, and then you have, a number of reporting cycles and tremendous detail in what the political committee can regulate, then that is considered an infringement on constitutional rights. Whereas if you have a lesser regulatory system, as Montana does, we have sustained our reporting and disclosure from challenge by our as far as it's gotten in Montana, which is Judge Christensen has issued an order sustaining the constitutionality. So it is an odd time, and I think if we're all going to get through this, we have to keep talking politics is what we need to do. We need to keep talking about candidates. We need to be talking about just civic discussion among each other about what we expect from an office holder, what is good for an office holder, what sort of governance we expect, and not get caught up into manipulation on single issue politics to the extent we can. That manipulation on single issue politics doesn't lead to anything good, and to the extent reporting and disclosure helps anything, it helps by taking away some of the manipulation of those of that sort of single issue politics.
Thank you.
Similar along that line, how can we strengthen our lobbying revolving door regulations and the ethics role to recuse from voting if money was taken from that industry or interest?
Well, We can. The Supreme Court has actually upheld a recusal requirement, but it's tricky in terms of what you define as a conflict of interest, and that would be a really nice way to go about these things. I suspect some of the candidates would see all sorts of contributions from new and surprising industries if there were a recusal rule, so that they couldn't vote on it. The lobbying piece, there's probably more that can be done in terms of lobbying as well. One little piece to keep an eye on is our lobbying laws are actually quite, like our campaign finance laws, are quite broad, but they have been pulled back a little bit in practice over time, and this hasn't been Commissioner Modell's main focus. But groups like the American Legislative Exchange Council, certain sorts of grassroots lobbying, the lobbying laws, they're important too, and that's a direct connection to legislators, and we might look at tightening those.
Okay, and just one last question. Is there any distinction made with money coming from out of state? Is it allowed? Is it regulated differently?
No. Actually, there is Montana tried that once with its lobbying laws, and our state Supreme Court struck it down. That's actually something that we might look at. I don't think you could regulate it differently, but there are things you could do with disclosure. I think it matters to us as Montanans, outside versus inside money. I don't care whether it's corporate money, union money, or whatever else. If it comes from someone outside the state who's not a constituent, and McCutcheon, by definition, you're not if you're giving to 435 House candidates, you're not a constituent. You're only constituent for one. That might be something we could do. We couldn't ban it, but we might look at ways, and the press already does this. Mike Dennison and Chuck Johnson's good reporting often sorts out the contributions by how much is in-state and out-of-state. We might do a little bit more of that. You might think of like a little nutrition facts label that tells you what's in your candidate's campaign and how much of it is foreign sources and how much of it are people who are actually in the district. And that might be it's really interesting, I think, completely fair and constitutional reform, and something we ought to all keep an eye out on is there's going to be a lot of money out there. You can at least look at, as I'd said, not how much money, there's nothing we can do about that, but whose. And in the district ought to account for a lot more than outside.
Okay, thank you very much, Paul. Professor Johnstone can stay around with us for a little bit, is that right? But Commissioner Modell has to leave because it's not legal for him to be here when we discuss the legislative referendum, which is going to be on the ballot in November. So let's thank him again. One more question for Professor Johnstone. One more question.
Bonus round.
Bonus round.
Lightning round's done.
That's right.
Okay. The question is, what about the issue of libel? Can an entity send out information that is not true about a candidate and not be held accountable?
So this is a great question that the Supreme Court may or may not, probably won't decide right now, involving an Ohio law. Generally, libel is not protected by the First Amendment. Libel is not protected by the First Amendment, but when you're dealing with public figures and on matters of public concern, and that's what candidate campaigns are, there's a very high standard you have to meet to show libel. So Montana has a political civil libel law, but it's been limited, and parts of it have been struck down by the courts. You need to show actual malice. And that's a very high threshold. And generally, when you look at campaign ads, if you look at them closely enough, it's really hard. They're very cleverly drafted so as to be untrue, but not actually to be untrue in a technical sense. They've mastered the false advertising line. So there's not too much you can do about it, and the court would be quite skeptical. In fact, a couple years ago, the Supreme Court just upheld or said that a person who was lying about receiving the Medal of Honor, a candidate, had a First Amendment right to do so. That the government could not criminalize that.
Thank you.